Well, good morning. This is Ian R. Crane, and I'm pleased to say that I was able to get up at a sensible hour this morning and enjoy my morning constitutional up here on the moors above Burnley in East Lancashire. This is the beautiful Cloudbridge Reservoir, and as you can see at this time of the morning, you pretty much have it to yourself. Well, later on this morning, of course, I shall be heading back towards Manchester and excuse me, there's bugs around here right now, I have to say. Anyway, I should be heading back towards Manchester to be back in the civil courts at 12 noon to hear Judge Pelling make his ruling, an interim ruling, following yesterday's hearing of Cuadrilla versus Persons Unknown. Well, first of all, let me make an observation. We are no longer persons unknown. There are 4 named defendants. And I want to take this opportunity to acknowledge the amazing work of the people who pulled the case together yesterday in a phenomenally short time. Although we had the documents for approximately 10 days, the first time we actually had an opportunity to sit down together was Bank Holiday Monday. And actually, there was only a few of us there. And then yesterday was the first time we were actually all sitting in the same room about 3/4 of an hour before the hearing was due to start. And, particular reference must be made to Benjamin and Sharon Dean for their absolutely superb work in pulling all of our arguments together. And the support of Bob Dennett and Joe Boyd, and of course the other 2 named defendants, Thomas Burke and Darren Dennett. And there were a number of people other than those who contributed behind the scenes. But it was a great team effort that enabled us to put together a cohesive and I hope coherent case to challenge Cuadrilla's attempt at effectively shutting down all peaceful protest. And I'm not going to say too much more about the case at the moment, obviously, because the judge will make his ruling at 12 noon. And then there will be a subsequent substantive hearing, which is currently scheduled for the 10th of July. And my counsel to my fellow co-defendants is that they should probably get proper legal representation at that substantive hearing. But I think that I may take the opportunity to retain my status as a litigant in person and hopefully be a bit of a loose cannon for Cuadrilla. So it is a concern, obviously, that a company such as Cuadrilla feels that the only way in which it can carry on doing business is to effectively put an injunction against its opponents. And, we'll make the observation that, this is an industry that 5 years ago, and by the way, I made the same observation in court yesterday, this is an industry that, when the moratorium was lifted 5.5 years ago, was trumpeting that it wouldn't proceed without getting social license. And such was the arrogance of both the government and the industry that they actually believed that they could achieve social license. And of course, social license actually means public apathy. It basically means getting the public to the point where they really don't care and, they're just going to ignore it. Or maybe I'll be more charitable, acquiescence, public acquiescence, acceptance that the industry has a role to play in the economic and industrial mix of the country's economy. Well, 5.5 years on, that isn't the case. And as more and more information, of course, comes into the public domain, much of that information, initially anecdotal, but now more and more supported by recognized and peer-reviewed academic study. So there is a problem here. The industry has a massive problem, and of course this is the third copycat attempt to establish effectively a neutering of the Articles 10 and 11 of the Human Rights Act, which provide for the right to peaceful protest, the right to freedom of expression, and the right to freedom of assembly. And Judge Pelling, well, we'll have to see. I think the arguments put to him were hopefully articulated in such a way to register with him. I mean, obviously he has a lot of experience in this sphere, but well, we'll just have to wait and see, won't we? So I will hopefully have the opportunity to do an impromptu live stream in the immediate aftermath of that ruling, which so around about lunchtime today, although I will endeavour not to clash with the UK column news at 1 o'clock. So over the next few months, we are really going to be able to see where the judiciary sits in terms of supporting a corporatist agenda or upholding the fundamental rights in a democracy to protest against an industry that does not have social license. And of course, there are other industries that have been in this situation before. Of course, the nuclear industry, one might argue, has been in this situation for some 60 plus years. But the issue with the nuclear industry is that it is just a single location at a particular time, or a couple of locations. And they tend to be obviously in coastal areas and a long way apart. So although there is opposition from a particular community and a handful of specific activists who have concerns about that industry, it can be localized. But here we are talking about an industry that is effectively targeting some 30% of the UK, and potentially could impact, particularly in the north of England, upon the lives of some 15, 20 million people. And it won't be a positive impact for the vast majority of them. So, with Lady Justice Asplin acknowledging that there were elements of Justice Morgan's ruling in the INEOS injunction that warranted a hearing in the Court of Appeal, with the UCOG application for a similar injunction, no interim ruling being made, but a substantive hearing scheduled for also, I think, around about the middle of July. And now the Cuadrilla ruling. So the question is, will the judge issue an interim ruling, or will he defer until the substantive hearing on the 10th of July? I have a gut feel as to what's about to transpire, but I'm going to hold any comment until this afternoon. So if you do happen to be in the area, then please feel free to come along. Your safety is absolutely guaranteed, because it seems that the Greater Manchester Police have deployed a unit of the TAU to provide us with security. And they will probably be both outside the courts and a contingent of them actually upstairs outside the particular courtroom. So your safety is absolutely guaranteed. So that'll be 12 o'clock, so come along there. And of course, if you are elsewhere in the country, please continue to get along to Preston New Road and show your concerns about Cuadrilla, who are getting ever closer to the point where they will be ready to frack. And my sense is that they are looking to get this injunction in place before they bring in the frack spread, which of course, the whole issue of the frack is still dependent on Greg Clark giving them permission to go ahead, which may or may not be imminent. But it's really important to continue to raise the awareness amongst the people on the Fyle Peninsula about the threat that Cuadrilla and potentially other companies across the north of England have to that community. And if you're over in the other side of the country, then there was a lock-on yesterday at Marriott's, which the Cuadrilla legal team tried to introduce into the evidence yesterday, but fortunately the judge rejected that. Not only was it not included in the initial bundle, the reality was, of course, that it was a lock-on against another company, iGas, and against a supplier, neither of whom have injunctions or effective injunctions against them or working for them. So consequently, it was an irrelevance. Anyway, I gather that the police in Derbyshire, their lock-on removal team, were otherwise engaged, and so after blockading the gates at Marriott's for the day, the crew unlocked and then returned home with the lock-on device intact. So a good day there. Well done. And this is what peaceful protest is all about. It's about creativity. And as I will explore, if not at lunchtime, then certainly next week, it's also about spontaneity and maintaining the element of surprise, because once there is any public pronouncement of intent, it has the capacity to backfire spectacularly and provide the corporations with an opportunity to pursue injunctions such as we have resisted in March of last year in the Manchester courts and again yesterday. Well, I think after today, I might just go camping again tonight and then head over to Nottinghamshire tomorrow, spend some time with my friends and colleagues at the Miston Springs Protection Camp. And meanwhile, wherever you are, and I know there are people in Australia who also tune into these broadcasts, and it's a long game. Anyone who expected a quick victory over the unconventional gas industry obviously was either a little bit delusional or just not paying attention. So we have to keep at it. We have to keep finding new creative ways to challenge this industry on every level, whether that's political, emotional, or physical, but peacefully. We have to find a way to shut this down. And then, of course, we have to use the community that has been built, that has rediscovered the importance of participation in the community stroke political process to challenge whatever else we perceive needs to be addressed to ensure quality of life for future generations. So thanks for joining me. I'm going to continue my walk around the reservoir here before heading back for some breakfast and then heading down to Manchester. And if you're in Manchester, then I look forward to meeting with you at lunchtime. Otherwise, I'm sure I will catch up with you later on today or on Monday morning at 8:30. You have a great day.